Welcome to the Thursday, June 20th, 2019 meeting of the Metropolitan Area Planning Commission. And I would call for public announcements, please.
Before we begin the agenda, the Wichita-Sedgwick County Metropolitan Area Planning Commission and the Wichita-Sedgwick County Board of Zoning Appeals would like to take this opportunity to welcome everyone to this public hearing. Copies of the agenda for today's meeting, the public hearing procedure, and Planning Department staff reports on all agenda items are available in the lobby of this conference room. The Planning Commission's and the BZA's bylaws limit the applicant on a zoning, subdivision, or variance application and his or her representative to a total of 10 minutes of speaking time at the start of the hearing on that item, plus up to 2 minutes at the conclusion of that hearing. All other persons wishing to speak on agenda items are limited to 3 minutes per person. However, if they feel that it is needed and justified, the chairman may extend these times by up to 2 minutes. All speakers are requested to state his or her name and address for the record when beginning to speak. When you are finished speaking, please write your name, address, and the case number on the sheet provided in the lobby. This will enable staff to notify you if there are any additional proceedings concerning that item. Please note that all written and visual materials you present to the Commission and the Board will be retained by the Secretary as part of the official record. If you are not speaking but you wish to be notified about future proceedings on a particular case, please sign in on that same sheet. The Planning Commission and the Board are interested in hearing the views of all persons who wish to express themselves on the agenda items. However, we ask that all speakers please be as concise as possible and avoid long repetitions of facts or opinions which have already been stated. For your information, the Wichita City Council has adopted a policy for all city zoning items. A copy of this policy is available in the lobby. The City Council relies on a written record of the Planning Commission hearings and does not conduct its own additional public hearings on these items. The decision of the BZA is final. Any appeal of a decision of the BZA is to district court.
Okay, we're going to recess the MAPC and we're going to go right into the BZA agenda. And agenda item number 1 on the BZA is approval of the March 21, 2019 minutes.
Move to approve.
Second.
I have a motion by Mr. Klossmeyer, second by Mr. Green.
Must abstain, I wouldn't.
Okay, Bill will be abstaining.
Flick.
I see Chuck Warren, Joe Johnson, and John McKay for the BZA minutes. So you still want to abstain? Okay. All right. So we have 2 abstentions? Yes. No? Yes. Okay. All in favor say aye.
Aye.
Opposed, same sign. Okay. Motion carries. Thank you. 802. I hadn't counted everybody yet, so. All right. And then moving on to agenda item number 2, BZA 2019-00024, city variance to reduce parking requirement on property zone GI. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we will take this item on consent.
Second.
I have a motion by Mr. McKay, a second by Mr. Green. Any other discussion? If seeing none, all in favor say aye.
Aye.
Opposed, same sign. Motion carries 10-0.
Move to adjourn. Second.
I have a motion to adjourn the BZA by Mr. Warren, a second by Mr. McKay. All in favor say aye.
Aye.
Opposed, same sign. Motion carries. All right, going back to the MAPC, we have agenda item number 1, approval of the prior MAPC meeting minutes of June 6, 2019.
I'll be abstaining.
Second.
Okay, so I have a motion by Mr. Richardson, a second by Mr. Warren. I have abstentions from Mr. Foster, Mr. Klossmeyer, Mr. Blick. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 703. Agenda item number 21 sub 2019 00011 one-step final plat for the Delano Hotel Edition. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody from the audience that would like to hear this case? Seeing none, we will take that item on consent. Item number 22, sub 2019 00014, one-step final plat for the Greenwood Cemetery Edition. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we'll take this item on consent. Agenda item number 23, sub 2019 00021, one-step final plat for the Paddock Industrial Edition. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? You all are making up for last time. Agenda item number 24, sub 2019 00023, one-step final plat, all metal recycling edition. Is there anybody on the commission that would like to hear this case? Is there anybody on the audience that would like to hear this case? Seeing none, we'll take that item on consent. Agenda item number 25, sub 2019 00026, one-step final plat for the Leak Edition. Is there anybody on the commission that would like to hear this case? Welcome, Mr. Johnson.
Thank you.
Is there anybody in the audience that would like to hear this case? Seeing none, we will take that item on consent.
Approval of the subdivision office. Make a motion to approve items 21, 22, 23, 24, and 25.
Okay, I have a motion by Mr. McKay, a second by Mr. Klossmeyer. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 11-0. Okay, moving on to agenda item number 31, VAC 2019 00012, county vacation of a portion of a floodway reserve to allow for building and structure on a property zone RR. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? We will take this item on consent. Item number 32, VAC 2019 00013, city vacation of a portion of platted reserve and platted reserve uses for future building construction. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we'll take this item on consent. Agenda item number 33, VAC 2019 00014, city vacation of platted front setbacks of multiple lots and utility easement to allow for redevelopment on property generally located. Yeah. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we'll take this item on consent.
Move we approve the public hearing vacation items 3-1, 3-2, and 3-3 on consent.
Second.
I have a motion by Mr. Green to approve, a second by Mr. Blick. All in favor say aye.
Aye.
Opposed, same sign. Motion carries 11-0. Agenda item number 4, public hearings 4-1 DER 2019-00001, amendment to the Community Investment Plan regarding renewable energy systems. I think we have to hear that case, so we will hear that. Agenda item number 4-2, CON 2019-00019, city conditional use for soil extraction of property zone SF5. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody on the audience that would like to hear this case? Yes, okay, we will hear that case. Agenda item number 4-3, ZON 2019-00018, city zone change from SF to TF3. Is there anybody on the commission that would like to hear this case? Seeing none, is there anybody in the audience that would like to hear this case? Seeing none, we will take that item on consent.
Moved.
Second.
I have a motion by Mr. Green, a second by Mr. Bill Johnson. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries 11-0. And agenda items in section 5, we will hear those. So let's go back to 4-1, and we have Dave. Welcome, Dave.
Thank you. What we have before you today is the proposed language for the amendment to the comprehensive plan that's outlined in your staff report. I would note that what we tried to do with the language is to clarify that the purpose statements and intent that was outlined are based upon really the recommendation of the Planning Commission from 2 weeks ago regarding the prohibition of wind. And what we did was change that to try to give some foundation of why we would do that, primarily concerned about protection of airspace for the aviation industry, a recognition that the rural part of the county is continuing to see a growth in interest for non-resident or non-agricultural development, primarily isolated rural residential, including on individual lots, but could also be on rural subdivisions. Also, we made a broad statement regarding the interest to maintain the mission of McConnell, that we're just trying to indicate that the idea of creating potential conflicts with their mission of training with the aircraft that they operate is incompatible with the idea of possibly introducing wind turbines into the Sedgwick County. So those are the bases of why those were done. And you got language there that was provided to try to address that. The idea being if you take action to adopt this as an amendment into the comprehensive plan, it will help provide a foundation for the ultimate decision if it is made to prohibit wind development or the wind farms. There have been some comments that came back based upon some overall review, and I don't know, Justin, how much you want to talk about that stuff. But we're continuing to tweak that, but we feel like, to a great extent, what we've tried to do within the language presented is give you a foundation of support that if ultimately the governing bodies adopt the amendments to prohibit wind development, the statements within the comp plan will at least provide a foundation to support that. It doesn't prevent that from being modified in the future as other things might evolve with respect to that industry. You know, if you'll recall, there was a comment made at the public hearing a couple of weeks ago regarding the idea of a different type of turbine that doesn't have the big blades, but was more, I don't know what they called that, and I looked at that, and we did do some research on it, but right now, those are not being deployed anywhere at a commercial scale that I can find almost worldwide, because they're finding that, one, they're not very efficient, and two, they're not always that reliable. And so that's what the information that is coming out of the industry. Yes, the technology is being explored, but apparently it's not reached the level that we're actually seeing deployment of that type of wind conversion systems. So with that, our recommendation is to act on an amendment and approve the proposed amendment language for the comprehensive plan as an addition on that, which will then support what was being done with the regulation amendments that were approved 2 weeks ago. So with that, I'd be happy to answer any questions.
Mr. Florence.
In your research, did you study what they had did around El Paso, Texas, with their wind turbines? Did you see those designs?
We looked at everything that I could find online of the various designs and alternatives of what they're doing. And right now, it's only the big turbines with the blades is the only thing I'm finding that are being deployed on large scale, at least.
I would suggest that you look at what they do in El Paso, because it's a large scale, and they don't have the big turbines, and they are efficient. So just, I'm just saying, you know, that's one option you should look at.
Okay.
Warren.
If the likelihood of anybody trying to come into the county based on the other restrictions that are out there in terms of location of airports and that type of thing, if somebody did want to try it, once we pass this, is there an appeal process or is there a conditional use process that somebody could come back in and say, I know this is your policy, but I think I've got something different that should be explored? What would that process be?
Well, if the amendments are approved that prohibit wind development, if somebody came back in later claiming I've got something that we think is more compatible, I would believe the only thing they could do is request that we go through the process to look at amending further the regulations to open up that window. There is, there's not the ability to appeal or ask for a variance or a waiver. That's just not an option
Okay.
at this stage.
Mr. Foster.
Dave, this is kind of a structural question on how this is laid out. And, you get the definition in here of what renewable energy systems is. And to speak a little bit to Chuck's question, perhaps that definition could be tweaked a little bit to give some flexibility for other types of renewable energy things that might come along we just don't know about on it.
Well, the language that you've got in the staff report is basically the language that was approved 2 weeks ago by the Planning Commission and going forward. That's still got to be reviewed by the governing bodies, and there's questions out that I think will probably manifest themselves with respect to further tweaks with, to help clarify other things. But to a great degree, our belief is you couple the language you put in the comp plan language just based on, and then also how we handle these things going forward, that we'll deal with the flexibility issues as much as we can without always having to come back and do this process.
Foster.
That wasn't my main question, but let me get to it. And that is in the actual amendment information itself. When you're looking at item PP and you start going through there, kind of get a sense that wind energy is possible, but then you get down into it and it just says, no, you can't do it. My question is, there's a lot of wording here about renewable energy when in effect it's only relating to the SECs. So I'm questioning, there's a lot of information here about renewable energy systems on site plans and things, but yet it's only relating to SECs, so it's just a little confusing. It might help to shift item number 2 and just right off the bat say all wind energy conversion systems are prohibited, and then go straight to what's required for an SEC.
Well, the original draft was intended to segregate what was going to be required regardless of what type might be presented, and then we broke out wind and solar separately. When the decision was made to prohibit wind, the redrafting did not combine at all. I mean, we could, if that goes.
That's what I'm thinking. If you considered adjusting the definition, then the amendment would stand as it is, the way you've got it.
We'll discuss that as we go forward.
Mr. Florence.
On each application as it is right now, this would have to be approved as a conditional use. Am I correct? If somebody applied today.
Well, there's a moratorium in effect today,
Right.
but
But if it's
if somebody if you're talking wind or solar or both? Wind. Well, right now, at least in the rural part of the county, it wouldn't even be taken. Before that, or if the moratorium was expired and we didn't get other amendments, then yes, it would be just a conditional use. We would not have any adopted standards of what's got to be reviewed, what's got to be submitted, or anything of that nature. But and we've stated that from the very beginning, that the current regulations would require a conditional use application.
okay, so then every application will stand on its own merits.
Yes.
Okay.
Mr. McKay.
Well, I think maybe my question was answered. We talked in advanced plans about separating the two, and you said that's where we came in originally, and now the way I read it, we're doing both of them. as one. Is that correct?
Well, no, the intent would be, and if we need to redraft this on the regulation side to basically just say, rather than list renewable energy systems, and then indicate, or just put on in as solar systems only, we can do that.
I mean, that's what I think we, at advanced plans, agreed to do, was to separate them, and that map you got up there is solar, and the map for wind is altogether different. That's one of the reasons why we got that map, to see what the differential was.
Well,
in
this,
areas of
this
use.
map is what we talked about after the vote made 2 weeks ago about prohibiting wind altogether and identifying around the airports the 1 mile concern for solar activity.
Correct, that's why I thought we was gonna separate them. So, wind is, because the mile limit is a no-no in Sedgwick County, except for 3 little bitty locations. What,
Yep.
possible to do that, and then solar would be separate, stand on its own.
The action of the commission last time did separate them. I mean, you voted to prohibit wind and to permit solar. And so that's what this language states.
Well, I think the concern is that we still, in provision PP, talk about renewable systems. We do state in there that wind is prohibited, and then we list certain things that have to be submitted and don't fully, apparently, because we still call out separately in 3 things that have to be done with solar, and 2 is the prohibition statement. That probably ought to be right up at the front, and then we just combine everything else.
General statement here is renewable energy systems, and you name both.
Well, by definition, they're both, can be,
Rules aren't the same.
no. We define them as both, and then there's definitions of what those terms standalone mean. And then, probably what needs to happen under PP is to indicate, number 1, that wind is prohibited, and then number 2, combine everything else together. We can do that as it goes forward to the governing body, or governing bodies.
Other
It's
que-
understood, then that's fine.
Yeah, other questions from the commission? Okay, is there anybody from the audience that would like to speak on this case? Okay. I will bring it back to the commission for action. Mr. Foster,
I'll go ahead and make a motion for this to move forward with the adjustment that Dave mentioned relative to item PP. I think that cleans it up real well.
Second.
okay, I have a motion and a second. Motion by Mr. Foster, second by Mr. Bill Johnson. Other discussion?
Just want to clarify that item 2, what you're talking about is moving that up to the top where it says is prohibited. Is that correct? Okay, thank you.
Any other discussion? Mr. Florence?
I just think that a blanket no is not in the best interest of Sedgwick County, and that each case will stand up on its own merits, and they would have to come through this commission and be approved or disapproved. Just to have a blank statement to say no, that's not taking considerations. Somebody in the southwest corner may want these, but then you have excluded them from them. Just because we got some testimony from people from the Northwest County, I just think this is a continuation of a mindset that has been present in this area for a long time, that we don't allow certain different new things to come in here. Because at one point in time, General Motors wanted to come here, Ford wanted to come here, and we didn't allow it. And so, I just think we need to get away from that type of mentality. But the safeguards are already built within our system, so that if something comes in that is not correct, we cannot approve it. We don't have to approve it. So that tells me that Sedgwick County is not a place where innovations may want to come into this area.
Thank you, Mr. Florence. Mr. McKay?
Dave, can you put up the wind map?
I don't have it within this slideshow. I don't. Sorry.
Benefit of the gentleman, when the map shows, we got a little corner in the southwest part, a little corner in the northwest part, a little corner in the place it could go, and it's not large enough to do commercial.
I remember the map. I'm cognizant of that. But I'm just saying, I would leave it up to people in that area. And maybe some property owners within that area might want to do
By
it.
statute, you can't do it within those circles. That's what I'm
Well, that,
trying to
in the
say.
southwest
Nothing we-
corner, well, I understand that, but I'm just saying there was some areas in that southwest corner would be big enough to do that. That was not in those areas. I remember those maps. I'm aware of that.
Mr. Foster?
I just want to follow up on Mr. Florence's comment. When I wasn't here for the discussion, and was surprised, shocked when I saw that, the prohibition on it. However, if you think about, we're an urbanizing county on it, and it's going to continue to be. So, and also what Mr. McKay mentions about the wind map and the reality of that, that's what got me comfortable that the approach is working, so.
Any other discussion?
I was the
Mr.
same
Warren?
way with Mr. Foster was until I saw the maps. And that's why in the beginning of the advanced plans, we didn't have this map. And then when they brought it back and we showed the difference, that's when we decided to separate them out,
Right.
because there is no place to really put one in Sedgwick County of any size. So,
It's, the practical side, when you look at the maps, the practical side says that it's not practical. But I agree with Mr. Florence that it's, just to say no, because, somebody may come up with something. I'm gonna vote against the motion, even though I doubt anybody would ever try to come in with this, because the area that would allow it in terms of size is so small, and the opposition that would pop up because of the proximity to urban areas is so great. I don't think it's practical, but I'm gonna vote to leave that option open.
Mr. Dool?
What is the difference between what we voted on last time and what we're voting on this time?
Well, the intent today is just simply to consider adoption of the language for the comp plan. We're not re-voting on the
Right.
amendment to the regulations.
The statute is. There we go. The statute is clear that the planning commission has to adopt specific language for a comprehensive plan. The language that we presented to you last time was not consistent with the action you took on the zoning, and so that's why we brought it back, to give you the language so that you would vote on that specifically.
And I remember a comment last time, that it was a two-part thing. The one part we approved last time, and then they said the second part would be brought to us, which is today. I just was wanting a clarification on differences, and from what I'm understanding, we've refined the language to be part of the comprehensive plan, and that's what we're voting on now, right?
That's correct.
Mr. Klossmeyer?
The kind of a legal question here, I guess. Are we opening ourselves up, or someone on a similar situation with the city right now, with the cell tower, are we going to open up the same kind of possibility here for Sedgwick County on banning something blanket?
You can never say never, I suppose, that somebody couldn't try to file suit, but I don't believe we are, Commissioner Klossmeyer. The thoughts I have on that are, first off, there's case law in Kansas out of Wabaunsee County, as the Zimmerman case that went up to the Supreme Court of Kansas. In that case, they actually had a pending application in front of them when they approved a moratorium, renewed it several times, and then actually went in and amended their comprehensive plan and zoning regulations to not allow it. Their basis was because they're in the Flint Hills. What's in front of you today is not the Flint Hills, is the comprehensive plan reason that the wind use would not be compatible in Sedgwick County. It's based on, I think, rural growth, suburban growth, aviation, those types of things. But essentially, based on Kansas Supreme Court case law, I think that you're in a position where there's case law that would say that this is a permissible act to do. There also another piece to that is that in that Zimmerman case, one of the aspects the property owners brought up was their property rights were being harmed because they had leases on their property. But the court said that those leases, that the rights in them had not vested because they were all contingent upon getting government approval for their zoning applications, which hadn't occurred yet. So I don't think by banning it, you're subjecting you're subjecting the county or the city of Wichita to liability on this. Doesn't mean a claim couldn't come forward, but I do think there's pretty strong precedent in Kansas that's right on point.
Okay, thank you.
Mr. Foster?
My initial motion was intended for the zoning amendment, not relative to this comprehensive plan discussion, so I need to withdraw that motion.
Okay.
I want to follow up on Mr. Warren's thought that I think if that definition of renewable energy is looked at and allows for flexibility of future unknown renewable sources, they could come up with something that would be half the acreage that's required for a turbine system today or something that might work. That's where I think we're hurting ourselves on this. So I think the comp plan should address that as well as the amendment. So I'm going to withdraw my motion.
Mr. Blick?
One thing I was just thinking about is more of a 50,000 foot, I mean, from the sky, you have multiple adjoining counties. So if we're just talking, we're west corner, if there's adjoining counties that does have additional land that could encompass a larger project and they come into our county also multiple. So I could see the possibility of, someone just wanting a small corner, but then there's an adjoining county also. That's something to think about.
Mr. Bill Johnson, are you in consensus with Mr. Foster to withdraw?
I would make a motion since he withdrew it.
Second.
So I have a new motion and a second by Mr. Dool. Is that correct?
And I was going to ask for clarification. Is the motion for the staff recommendation in terms of the comprehensive plan?
It's what Dave talked about, the adjustments that was going to be made.
And to clarify, those were adjustments to the zoning code provisions. But I think that just from the legal side of things, I think both Jeff and I are of the opinion that and agreed with planning staff that those changes could be made because it's more or less formatting changes.
Okay.
Just to clarify, was that your motion?
That's fine.
Thanks.
Mr. Dool, are you good with that motion?
Yes.
Okay, thank you. Mr. Foster?
So the motion is killing two birds with one stone here. It's covering the comp plan issue as well as those adjustments to the zoning code as this goes forward.
I don't think so, because we already heard a vote on the zoning code at the meeting a couple of weeks ago.
And just to clarify maybe on what Scott said on the vote 2 weeks ago, what you had in front of you 2 weeks ago on the zoning code, when you voted for it, was essentially by saying that you voted to not allow wind and to insert a provision on that. That was more or less a deletion of provisions that were already in there. As Scott mentioned on the comprehensive plan, there's going to need to be wholesale new language added in there, and that's what planning staff has presented today. And I think all that's really in front of you today is the comprehensive plan proposed amendment. So,
And as staff, we can move item 2 to item 1. Then, it still says the same thing. They're just in a different order. It just makes it easier to read, but the language doesn't actually change.
So, again, to clarify, it would not be appropriate for us to, say, put in a amended motion here that redirected what we're doing with wind to be in conflict with what we voted on last time.
just to make sure, you're asking if it would be appropriate for you to essentially change the position as a planning commission on this issue. At this point, I think your recommendation's been made. I'm trying to think of any precedent for changing your direction once you've already made a recommendation. I think that recommendation goes to the governing body. I guess you could have inconsistent recommendations. I'm not sure that would be atypical, but certainly possible. Let me, yeah, go ahead,
Yeah,
Scott.
but I mean, I guess I have not heard any discussion about wanting to change the zoning language other than reordering the item, making item 2, item 1, and item 1, item 2. That doesn't change the language, it just changed the order of the language that's in the code. It still says the same thing, it's just you don't have to read item 1 until to learn what item 2 says.
Mr. Green.
I'm sorry. From a Robert's Rules type of answer, you would have to make and approve a motion to set aside the previous ruling for reconsideration. That would have to be voted on, and then you would start over from scratch from that perspective, but it's not frequently done, so.
It's also not anything that we notified anybody in the public that
Yeah.
you might do.
Green?
So the ship has already set sail on the possibility of somebody coming before this body to have a presentation on wind power on a case-by-case basis? Is that what
That's
I'm
the action of
understanding?
the
If
planning
we,
commission at the last hearing.
that was at the last hearing, and that was what was decided then, so.
And I think it's
So
important to
hands
note
are tied
that
at this point to pass the zoning and
Well,
option
the
without
zoning
going back.
action was recommended for approval at the last hearing. What we're presenting to you today is a comprehensive plan amendment that is consistent with the action that you took last time. Because the comprehensive amendment that we presented to you was different than the action you took.
and the intent, and kind of the intent from the 6th was to get you the language based upon what the decision was made for the zoning amendments, but was not to open that up for reconsideration because it wasn't notified that way. But I think it's also important for everybody to remember that that's the recommendation of the planning commission on the zoning amendments, but that still has not been acted upon by the governing body. And they may or may not agree with your recommendation, and they may ask you to reconsider or look at other alternatives. We don't know yet.
Okay, any other questions or any other discussion? Okay, seeing none. All in favor say aye.
Aye.
Opposed, same sign. Aye.
Aye.
So motion carries 8, wait, 8-3, 9-3.
Yeah, there's 12 here. I got 2 of them. I got Warren and Florence.
Down at the-
Oh, no, Mr. Foster is a no, I'm
8-4.
sorry.
Okay. 8-4. Got it. Yep.
Okay.
All right, moving on to agenda item number 4.2, CON 2019-00019, and it looks like, Dave, you presenting on this case?
Yes, ma'am.
All right.
This is a request for a conditional use for soil extraction on the property outlined on the shot on the screen. It's the roughly about 30 acres of ground that's a part of what was originally platted as North Gate. And as we outlined in the staff report, there's a replat coming through within the next week on this area. You just approved the rezoning of the property to the south of this for the duplexes, which is consistent, as you can see, with the existing duplex development happening right north of that Walmart. And the Walmart is right here, and the area that you did the duplex zoning on is that location. Anyway, Jim jumped ahead on me. The site plan proposed and submitted as part of the conditional use application shows the area, the boundary of the zoning action and the intent of how they intend to develop roughly 30 acres of ground that would be excavated. It would result in essentially a pond on the property. The note we make in the staff report, and I think this is the reason that Russ wants to address this, is that we do have the preliminary plat submitted for the replatting of this area, which shows here and roughly the area outlined around this area is where that plat's going to go. And you can see the intent is to create some lots and a couple of cul-de-sacs to come down into this area. And our concern was that there was an inconsistency here and needed to be addressed, and we wanted to bring it to your attention. We've got some pictures of the area. This is roughly looking down at the side. It's kind of hard to get to this particular property because there really isn't any way to do it from the public roads. I've got really only just one picture that took from the area on this street to the north that was looking down southwest into the area where it would be excavated. So I'll leave that up there. And I think Russ is going to address the question that they've got regarding the proposal of the 30 acres of excavation versus what they're showing in their preliminary plat that would retain some streets and lots. And with that, I'll be happy to answer any questions you've got about what's going on. I will tell you this went to the District Advisory Board 6 last night. They voted unanimously to recommend approval of the rezoning. They did pass a recommendation of approval on this case by a vote of 4-2. There were still a couple that were objecting, so happy to answer any questions.
Yeah, I don't have any issues whatsoever with the zoning request, but the site plan that you're showing us has nothing similar to what we have in our packet as far as the street layouts and such.
On this on this one?
On that one or the other one that has the lake there, it shows that these 3 different phases actually on this map show them to be tied in with access, having many points of access, and what you're showing us here with this site plan doesn't reflect that same access, which I understand that at this meeting, we're discussing the zoning, not the platting piece of that. So I
You
just
get to
wanted
review the plat next
kind of
week.
give you a heads up that is an issue that I'm concerned with. Zoning is fine.
So,
Other questions for Dave? Mr. McKay?
Well, if I read this, I've got the preliminary plat, all we're doing is eliminating 2 cul-de-sacs from the north to put in a lake or a pond.
well, that's what's proposed. It's not
Basically.
platted that way now,
No, I understand, that's basically, that's all we're talking about.
and that's what the staff's concern was, yes.
And that, it matches.
Cover map doesn't, so.
The cover map is how it's platted now.
Right,
Yes.
right. And that's the concern, because we have had discussions in the past over the access into these various subdivisions that are limited at best.
Other questions from the commission? Okay. Agent or applicant, if you'll step forward, state your name and address, you'll have 10 minutes.
Russ Avey, Boffman Company, agent for the applicant. I understand, so there's been some discussion here this past few days regarding what our office filed for the conditional use and then subsequently filed a preliminary plat on. So I'll just try to walk through this as I did last night. What we're trying to accomplish with this conditional use and this conditional use site plan is to illustrate the maximum area that would be available for excavation, predicated, of course, on the idea that we would have to replat at some point in the future. That point in the future came prematurely. If we would not have filed that preliminary plat, you would have had to listen to me this afternoon. So that's on our office. But it does bring up larger access. Mr. Richardson was one that first brought it to our attention, and I can't stand up here and say that I disagree with some of those concerns. So the issue for the client is that there is a market for this fill material for several major area construction projects. The calculus that they're doing is whether or not this fill material is worth more than the potential sale of X number of lots in this subdivision. As you know, this is about a 13-year-old subdivision, only partially developed. And so they are thinking from that standpoint. It may be a situation, and this is what we're asking for, is basically flexibility by striking the first sentence of the first staff recommended condition, is that both can ultimately occur. We can excavate this area and then fill it back in as market demands in the future. We can leave it excavated as one larger pond and then just not record the preliminary, or just not finalize the plat that has been filed. If we kept it as one large plat, you would see a vacation case come through to vacate the remaining portion of that plat. So again, we're looking for flexibility, and I don't think we're giving up anything by that request, but I would stand for any questions you might have. I know there's an audience member here that may have an issue that we have yet to consider.
Questions from the commission? Okay,
Thank you.
thank you. If you'd like to step forward and state your name and address, and you'll have 3 minutes.
Hi, my name is Tyler Rail, and I live at 5714 North Meridian Avenue. So my biggest problem with this whole development is what you addressed a minute ago, is the access. And I have a family, a wife, and a son, and my house is located right across.
Yep, if you'll stay at the podium and use the mouse.
Oh, gotcha.
Thank you.
So my house is located right across from this proposed entrance that they have to this property. It, in my opinion, it endangers my family by having more traffic, more potential accidents. This is a busy road. This is a fast speed limit through here. It's 45 and people drive 50 to 55. I have a son that's 1 year old, and I don't like the thought of everybody that turns out of this property turning into my house. They had the opportunity when they developed this property to make an intelligent decision on how they were going to do this. Right here is a cross street, and they chose not to utilize this cross street for an entrance and exit that would eliminate the problem that they're even running into now. And they could potentially have put stoplight there and done this the correct way. Especially if these are multifamily units or, duplexes, that means a lot of traffic, and the only way out is through here. The current temporary exit is where this roundabout is at currently, and that works for the small amount of traffic there. But with the addition of all this other property, I'm concerned about exiting here rather than exiting on an actual street.
Any questions from the commission?
If he could show me again, I'm sorry, sir. I was having a hard time following the mouse. You said there was another access point, and I was trying to see where you were.
On the other side of the street, there is a 50, can you go to a view that has on the other side of Meridian? So 55th Street would have been a location where they could have potentially put in a stoplight and had a street go all the way through, rather than a street that tees into an intersection into my property, into my front living room, into the glass in my house, into my son's bedroom, into all of this, and obviously will hurt my property value quite a bit. That's not my main concern. My main concern is my family, and I mean, it's obviously wasn't considered from the beginning of how they're going to properly allow this amount of people out of this property.
Other questions from the commission? Okay, is there anybody else from the audience that would like to speak on this case? If not, Russ, would you like to have a rebuttal?
Again, Russ Avey, Boffman Company, agent for the applicant. I don't really think that this gentleman's concern is germane to the application in front of you today. It would certainly go into a lot of the issues that Commissioner Green and Commissioner Richardson had discussed about accessing the plat at large. But there again, this road has been in existence, design-wise at the least, since 2006. So that, I guess, is water under the bridge, so to speak. But there again, I'd just like to reiterate that we are seeking a removal of the first sentence of the first condition on strict compliance of what we would argue is two mutually exclusive application processes, fully realizing that that may impact the subdivision committee's vote on our preliminary plat. I'll stand for any questions.
From the commission? All right, thank you.
Thank you.
I will bring it back to the commission for action.
I move that we approve with the striking of the first sentence in item 1 that Mr. Avey was requesting.
Second.
I have a motion by Mr. Green, a second by Mr. McKay, and a question by Mr. Foster.
And Mr. Green, just to clarify, that will bring it back to the subdivision committee for a final look, right?
Oh, yeah,
Okay.
absolutely. Yeah, this is just the zoning piece of this.
Mr. Richardson.
Yeah, I mean, we already have a preliminary plat filed, and so somehow we'll need to reconcile it at the preliminary plat level, and of course, preliminary plat doesn't really tie anybody to anything. So in the meantime, he will be excavating what's already platted, but that's not necessarily unusual to do that. I think the issue will come at some point down the line when he needs to replat the north end of this. And that, what Russ is saying, that's going to depend on how much of this he excavates. You know, if the market goes away in the middle of it, then he might only excavate half of it. And the plat would look entirely different at that point in time.
So let me get Mr. Bill Johnson, then I'll get Mr. Foster.
I guess what I'm going to say, being in the construction business, good feel for building sites is getting harder and harder and harder to find. Takes weeks to find some, so there may not be any of this plat that's ever developed.
Mr. Avey wasn't laughing. Oh.
Mr. Foster.
I just want to mention to the gentleman that was the speaker, just please keep an eye as this goes forward. The critical point will be at the subdivision committee level when they discuss access.
That's correct.
No.
That meeting will be on June 27th at 10 a.m. You just did. Yeah, the subdivision applications don't require mailed notice. There's just a sign that's posted on the property. And so I'm guessing that sign is probably posted there now. Yeah, 10 o'clock next Thursday.
Other questions from the commission?
One thing to consider in this application, the excavation area includes platted street right-of-way. So likely, the excavation's not going to occur until a replat occurs, because the applicant does not control that street right-of-way. See, Wichita does.
Any other questions, comments? Okay, if not, all in favor say aye.
Aye.
Opposed, same sign. Motion carries 12-0. All right, let's move on to item number 51, DER 2019-00006, proposed revisions to the MAPC bylaws. Scott, are you heading that up?
Or do you want to
Okay,
discuss it, Justin?
I can do it. Justin Wagoner, Assistant County Counselor. I'll give just the background on this briefly. I guess kind of the history was that in talking some with planning department staff, there was some discussion of meetings that may have been before I'd helped advise on planning commission matters. So I don't think I remember being at one of them, but where subdivision committee would have a very small group of members, one or two perhaps. And I think this was a handful of years ago that would constitute a quorum at those meetings. And there's a particular statute in the Kansas Open Meetings Act that was last amended back in 2015, and I don't have the track changes version for what that change was, but the statute, it's KSA 75-4317A, changed to where it says that a meeting means any gathering or assembly in person or through the use of a telephone or other medium for interactive communication by a majority of the membership of a public body or agency subject to this act. The concern on that would be that it appears that the Open Meetings Act has defined a meeting as requiring at least a majority of the membership of, whether it's the Planning Commission or, subdivision committee or advanced plans. And so that's kind of the idea and of why both Jeff and I had worked with planning staff to come up with some proposed revisions to the bylaws. I'll just go through them briefly. Starting on, if you have it in front of you, section 6, which is on page 3, the definition of quorum was changed to just simply say a majority of the members of the planning commission would constitute at the MAPC meetings quorum. Also, and stop me at any point if you have any questions. Moving on to page 6. Under the subdivision committee, one of the biggest concerns I think staff had on this was you want to make sure your subdivision committee can have a quorum. So we didn't want to have any of these changes jeopardize the ability to reach a quorum. So we've clarified because a majority of 6 is the same thing as a majority of 7. So there was a thought that the subdivision committee should be 7 members. I thought I heard somebody say they thought it was 7 members. I think at most time, is that correct, Scott? Is it actually 7 members?
The current bylaws say that it's 6.
Okay, and but
It may have been 7 at one point.
part of the thought behind having a quorum is 4 is a quorum of 6 or 7 under the Open Meetings Act. So that there might be advisable to have it at 7 just so that you could more easily, you'd have 7 options to reach your quorum. We've added language to say at least 3 of the members would be from the city and the county. I think that's similar to language that's already existing. And then the last few sentences of that, this is where I was talking about making sure that you would have some flexibility to get a quorum, would be that the chairman would be able to appoint 2 members as alternates to the subdivision committee. These alternates, and I think what's in mind here, and I'd let Scott speak to this, but it would be that the chairman and the members of the planning department staff, if there was concerns about not having a quorum for a subdivision committee meeting, and the same thing would apply to advanced plans, there could be some coordination in terms of planning staff trying to reach out to those alternates to get them, see if they'd be able to attend. Because again, you don't want to hold up plats, you don't want to hold up the vacation cases, you don't want to hold up the advanced plans items either. You'd like to be able to have a quorum. And so really similar changes are also proposed on advanced plans. And that's, I guess on page 7, there's a minor change about, just a change consistent with all the other items that I already discussed, but be happy to answer any questions. And just so you know, it takes a 2/3 vote of the planning commission to amend the bylaws.
So I guess I don't understand why, if we've got 14 members of this commission, we wouldn't automatically have 7 on each of those different committees.
One of the reasons why is years ago when we reviewed this, you have the chairman and the vice chairman that are automatically on either one of them. Now, we changed a little later on that the vice chairman became the chairman of the advanced plans, and that's That's the reason why I think it
Okay.
is the way it is today, is because of that reason. You two are automatically, by your position, automatically on both of them. That gives you your 7.
Where you been at the subdivision
We
committee?
leave it,
Either one of you.
leave it 6, yeah, well, but we could be. I mean, if we became the alternates, then we could be, I could tend to be the chair of the advanced plan, but I would be an alternate for the subdivision committee. So if we knew that there was going to run short, I could attend and already
Designated right now. You can say the chairman or the vice chairman must be one of the 7 members.
Other questions?
Not a question, but a comment that the current MAPC has got a lot better record of attendance than some that we've had in years past. Sometimes we struggled at different times through the years to have a quorum. It's been a while since we've done that. I think the subdivision committee is doing better, but I know there have been times when there was just 2, and I think maybe once or twice there was actually 1. They've had a meeting that he had to second his own motion, and then
And he was beside himself when he did that.
so that I think that as this goes through, then I think it becomes incumbent upon us that if we're not going to make a meeting, that we let somebody know in advance. I think that in times past, we've been a little bit lax on that. We've assumed that there's going to be a quorum there. And all of a sudden, more than 1 or 2 people don't show up that we thought were going to show up. So it becomes incumbent on all of us to make that effort to let either the chairman or the staff know in advance if we're going to have trouble to be there, if we're going to be late, so that we know what's going on.
Mr. Green, do you have a comment?
I was just going to say that the subdivision committee has, I don't ever recall, of course, I haven't been on it for that long, but I don't recall meetings where we had 1 or 2 only. But I guess that's always possible. The comment that I was going to make was that we've had discussions on the committee itself pertaining to the quorum issue. And I think we're doing I think probably subdivision or advanced plans is probably doing the same thing, where we do notify people when we're either going to be late or not going to be there at all in advance. So I like the idea of having the chair and the vice chair being appointed to those committees so that we do have the best possible option of having a quorum in attendance.
I guess, do those meetings meet at the same
No,
time?
no, we meet on the opposite Thursday of
Okay.
this meeting, but you guys, I think, the advanced plan meets the morning of
Yes.
this meeting.
Mr. McKay, do you have a question?
Yeah, I don't worry so much about advanced plans because we have a schedule and it's only meeting once a month. But subdivision is not that way. And it's not just these members that are affected. What if we're short of a quorum and we know that before? Do we have to contact all the utilities? Everybody else is supposed to be there? Because that's what a subdivision is all about. Say, oh, you don't have to come today because or do we proceed?
Procedurally, you have to.
Were there or not?
Right, procedurally, you have to have the meeting, anybody that's present, then announce at that time that there's a lack of quorum. You can't cancel it prior to the time based on the assumption that somebody may not be there, so.
So there's going to be duplication then?
Yeah.
Because you have to hear it the second time when there is a quorum?
Well, you wouldn't hear it the first time, you just cancel the meeting, but everybody would have to show up to hear that the meeting's been canceled.
It is my understanding then that those items that would have been at the subdivision committee meeting would then be heard by the entire planning commission the following week? Is that,
And it could be done that way, certainly,
yeah.
unless somebody
Yes.
wanted it deferred for
Mr. Bill Johnson.
2 weeks.
I guess that's my question, because I have had a couple subdivision meetings where I was the only one there. But if now we got it set where there's not a quorum, what takes place? Does this moves on to the full planning commission the next week? and we go through all the subdivision items?
That'd probably be the cleanest way to handle it. I think and I defer some of the thoughts that Jeff and planning staff might have. If you wanted to, out of an abundance of caution, to add something to say that in your bylaws, you could. But I think that just planning department staff could just presume that. And like Jeff said, if you had a meeting where there's only one member there, they could say, well, we can't have a meeting under the Open Meetings Act. We can't take any official action. The planning commission as a whole will hear this item on such and such date and time, and then the planning staff could plan to give the whole presentation at that time.
If we didn't do that, it's going to delay the subdivision items.
Exactly, and that's what
Recommendation
part of the
time.
concern was. We didn't want this to be something that caused delays.
You could have 20 items on a subdivision agenda if one's missed. And then, if an applicant wanted to have it heard in front of subdivision rather than MAPC, they could ask it to be
For the
deferred.
option.
But they would be the one that would be in control of the
Okay.
deferral as opposed to us putting them back for a month, so.
Mr. McKay, and then I'll get you next.
Well, again, you say if we move it on to the general planning and we make the decision without hearing from utilities and everybody else, that means, where are you gonna have anybody to seat? I mean, let's be realistic about this whole thing, Say, well, it goes before, in my opinion, if you're gonna do this, then let's say, all right, if there's not a quorum there, just notify everybody there's not gonna be a subdivision that day. Or when they get there, say, I'm sorry, if there's not enough quorum, we can't have it. Now, that's why I'm saying, do you wanna hear it, or the ones that are there? Or you can hear it, but you just don't act on it. That way your other people, you can get.
But you can't, what do you do with it then? If you've got one person here that hears it, what do you do with the results of the hearing?
Well,
You can't take an action
but the
to,
staff can record what the utilities are saying and make that part of the presentation.
that
later
becomes
on.
part of a meeting that you can't have.
Well,
Unfortunately.
the other thing is,
I think what I'm trying to say, what you guys.
the other
are saying.
thing is staff's going to have the information that utilities would have for the subdivision meeting. That could be passed on to us at the full planning commission. So it's not like we're going to lose some.
Mr. Warren, got you next.
I'm looking for a solution here. Is it legal or permissible for the chairman to temporarily appoint one of the other members, say from, let's take subdivision committees, only going to have 2 people show up. Can the chairman appoint 2 people from advanced plans for one meeting to show up to the subdivision committee to follow that quorum?
It is a subcommittee of this committee. So
I can appoint, if I, chairman or the chairman could appoint anybody temporarily for a
Right.
particular meeting if we knew in advance
Right.
that we were going to come up short.
And you could
Other people fill the
also
gap.
keep in mind, somebody can appear by phone. In worst case scenario, that's permitted to be in attendance. And I understand there could be a scenario, even with these precautions, where, I remember I had a case and the attorney was late and everybody was wondering what was going on, and he did a deer coming into court and, just didn't have time to call and say, hey, I'm not going to be there or whatever. Things happen, kind of a thing like that. And that could be the case, and it may be that whoever's finds out on their way or just finds out immediately they're not able to be, then it didn't give us enough advance notice that the alternate is tied up and can't come. So there's all those scenarios are going to take place. We're just trying to,
If we're not restricted by who could be on it, then we could give the authority to the chairman
it would be
to
more like a
make an
phone tree.
appointment.
Yeah.
Temporary.
Then you better remove the fact it's gotta be 7 and 7. Sometimes it might not be 7 and 7.
Well, you just have to have a quorum. So you just need to have 4 of the 7 or 4 of the 6.
But I'm talking about equal amount from each, the city and the county is in here.
Yeah, I see.
Oh, I see what you're getting at.
Mr. Foster,
Up something real critical here, and that is, when we have our documents at the subdivision meeting, it specifically says subdivision and utility advisory committee, and that's what's in the subdivision regulations. And then you come over here to our bylaws and it says, and shall recommend action to the commission on all matters coming before it for final recommendation. To me, we're skipping a step there if, say they have this whole agenda and they say we're not going to have it, and then, we're going to deal with it at the full planning commission meeting. There's something missing there. And I think that needs addressed in the bylaws where we have an out somehow that it can go to the full commission. But I get concerned about bypassing the utility piece of this because there are real critical discussions that come up during those meetings that are very helpful in making that recommendation.
Can do that? Oh, yeah.
Actually, what you listen and base your judgment on is what they recommend that you can and cannot do.
John, if there's not a meeting, you don't think they can pass that information on to staff?
Was my question. Could they go ahead and have the hearing and have the staff pass it on to if you're gonna hear it, if we decided to do it with a full planning?
If they can't, then we
Planning
can't hear it
commission.
then either, so.
I think to your question, Commissioner McKay, I think they could pass along information. Certainly, there's no reason you couldn't have that, but I don't think you could call it the meeting or the hearing or anything like that.
I'm just
but,
simply
yeah.
stating, you go ahead and hear what the utilities have got to say and you pass that on. You're gonna have it to the planning
Yeah,
commission.
it would essentially be planning staff may meet with property owners who are looking to do something. They may meet with a utility company on it. It'd be like that, like a meeting like that, talking about something, but not actually a meeting under the Kansas Open Meetings Act. But yeah, I think that could be allowed as long as it's not, as long as everyone understands that's just a discussion about a particular item, but it's not a formalized meeting.
Sometimes in particular situations, negotiations between the utilities and the developer right at that time happens at the subdivision, do they not?
So, and the other thing we'll have to consider, and I'm sorry if I'm interrupting, but a lot of times you guys in subdivision will say, I got a question for the representative from the fire department, whether it's city or county. If the matter is sent directly to the MAPC, we would have to have the same staff individuals here as we would at the subdivision for you to be able to ask those kind of questions. And so I hadn't thought of that, but,
The utilities could be represented at that MAPC meeting also.
Sure, yeah.
PC.
Now, there's a lot of times where, no further comment or whatever, and if there is something that, maybe a staff member could bring up the question, and we've brought people from MAPC up here, so there could be like somebody, if there was a question related to fire, or they had a concern or something like that, it would be the spontaneous questions that you guys might have of those individual departments that would lose. And I think it's crucial, because I know that happens quite a bit.
And Commissioner Foster, to your question on the language on the shall recommend action too, I think on one hand, especially what Commissioner McKay was saying, you do want to make sure that you get input from those folks. But if there was language added to that sentence that said, except in the event of the lack of a quorum for a regularly scheduled meeting or something, would that be the kind of language you'd have in mind? Is that?
I'm not excited about it because I think it's subterfuge is good. It might be the only solution here.
Mr. McKay.
I brought this up the last time. I said, why are we doing this? And other cases, if we do have a substitute, whether whom it ever may be, and you call them at 10 o'clock in the morning and say, we're going to have a meeting at 10:30, can you come? You say, yes. All you're is a dead body sitting there because you haven't got any of the information. You don't even know what's going on. A lot of people that hasn't been on subdivision in the past don't understand the process which happens in the subdivision portion of it. Because it's just, you sit down and really work out plans that got presented and the utilities say, well, you can or you can't, and blah, blah. And so it's a don't use the word negotiation, but it's almost like a negotiation type of situation there. So that.
This is not optimum and ideal. It's kind of in a crisis situation. We have a policy for what we try to do to ensure that we do have a quorum. If we don't get it, we don't get it. Unfortunately, the Kansas Open Meeting Act just says you have the meeting. You don't have to have a meaningful meeting. So your point's well taken, but we're just trying to provide us with some kind of a basis for a process to try to fill the gap if we know we're running short. Hasn't been the case, but it's got some.
Can you go back then and do some rewriting of this so that
Certainly.
it meets, you've heard most of us concerns.
I'm going to make a motion. I'm going to move to approve the recommendation with the following changes. Give the chair the authority to temporarily appoint members from the full MAPC to either committee as necessary to achieve a quorum of 4. To keep as a guide the 3-3 split between county and city appointees, but eliminate the requirement of an even split between those two, again, in an effort to make a quorum.
Well, and that is just who is appointed to the committee. That doesn't have to do with the alternates. The
Right.
3-3 split is just who's actually on the committee.
I would second that.
Okay, I have a motion by Mr. Warren, a second by Mr. Green. Mr. Foster.
With Mr. Wagner's suggestion to add to the subdivision committee that it's going to be a rare event that we don't hit that quorum, that it could go on to the full MAPC, just with the reality understanding that utility folks are going to have to be invited. It's going to be on rare occasion. But I think that would kind of button it up if something happened.
I think the important thing here is that we ask for a commitment from the members to let somebody know if you're not going to be able to attend these committees. I mean, I work with a lot of boards in this community, and that's an expectation. We're all adults here. I mean, unless we happen to hit that deer or have a flat, and I think in most instances that doesn't happen.
If we
I
can't
think-
come up with 4 out of 14.
Well, I think if I have a meeting that conflicts, I generally know that several days before, and I let somebody know I'm not gonna be here. So I think that's an expectation that we should have of everybody that serves on this commission. If they're not gonna be able to attend a commission meeting or a committee meeting, to give notice of that. I just had to put that out there.
I had maybe a suggestion is next Thursday at subdivision, we kind of talk about this a little bit with the representatives from the utilities and kind of get their voice on it. And then we can kind of take what they think and make some changes and bring it back to this body. But I think it might be a good idea to see what they have to say about it.
So as of today, if we did not have a meeting, is there a statutory path that this takes? Does it then automatically go to the planning commission? Are there any notices that we miss? If it doesn't, is it the choice of the applicant?
Well, you can't take an action of any kind during that time, so it would.
No, but I
to
mean
my
it-
understanding, it would just roll to the next regularly scheduled meeting, which would not be the MAPC, but the subdivision.
So if we take no action, then the official path is you wait until the next subdivision committee meeting.
Yes.
And the only reason to add anything is to save a week with perhaps a less than you're going to, instead of waiting a week for the planning commission, you're going to wait 2 weeks for the subdivision committee. So you're going to wait another week.
And
And,
another week for the next planning commission.
well, I understand. It all gets rolled forward. So
Yes.
the question is, do we want to, and if we say we want to change that, how do you do it? Is it part of our bylaws that can say it's now going to roll to the planning commission and not the subdivision?
I think that's the only place I could think of where it would take place if it's not prescribed by statute or some other.
And then what if the applicant says, I don't want that, I want it to go to subdivision because we've got some issues? Is that his prerogative to do that? And Mr. Johnson's shaking his head, but is that the case? Do they have that prerogative? If we say, no, I'm sorry, you got to hear it at the whole planning commission with a room full of people who don't understand what's going on.
I think you could have the bylaws say that. I mean, kind of Jeff, like you indicated earlier, you could say that it could go to the next planning commission meeting, or if the applicant would prefer it that it go to the subdivision committee, it could still go there. I think the applicant would probably be the party who, I mean, as long as the anyone who wants to provide comments would be able to provide comment at the planning commission meeting as a whole. I don't think there'd be any harm there.
But I'd
They'd
like
still
to
be
give the
heard.
applicant the option to say, no, let's go ahead and,
An applicant prior to a meeting could come in and say, I want this deferred.
okay.
So in effect, that's what that would take
Right.
place, is it say, I don't want it to go to MAPC, I want it to go to the next subdivision.
But unless we
meeting.
take some action today, it's going to go to the next subdivision committee. It's not going to go to the planning
Don't
commission.
have any rules of which way it goes at this point.
Was,
Mr. Green?
I think at the end of the day, the planning commission is the one that actually will wind up approving anything that is recommended by the subdivision committee. Is that not correct?
Correct.
So, yeah, I think we're spinning a lot here, spinning our wheels a lot, but the subdivision committee is recommending approval or denial, and it's the planning commission that has the final say on anything that is.
Well, from the flip side of it, being a developer, if I was bringing anything before the subdivision, which people that deal with people on the subdivision committee, and I want to bring my plat to this group, with them not having the knowledge of it, whether it be what we get here or anything else, I don't think that's going to happen. I mean, all the developers I know will not do that.
Yeah.
And, in the development community, it's kind of like the Army, hurry up and wait. Well, we're always in a big hurry to get it platted, but then it takes us another 90 days to get it done.
So we give them the option to.
Well, yeah.
I think that's
Yep.
why it's so important for people to notify if they're not, if they're not gonna be here, and they know ahead of time.
No, I don't disagree with any of that. I'm just saying there's a lot of things other than just saying we're going to change the rules.
Sure.
Should be taken into consideration.
Sure. All right, any other comments?
I got something after we vote.
Okay,
I might make a point here, that you've made had a lot of conversation about the motion, about something that's not in the motion.
We ought to hear the motion again.
Mr.
The motion has
Warren,
nothing to do with what happens if we don't have a quorum. My motion only has to do with the recommendation that is here, that we approve, that the chairman have the authority to temporarily appoint members to either committee if necessary to make a quorum, and that the appointment of a temporary member would not have to follow guidelines of this even split between county and the city. We would keep the same rules in place.
all right. Mr. Foster, you have one more question? Comment?
okay, so if this takes effect, are we adding another step here? Because if this is discussed further, not the motion, but if we discuss this further at the subdivision committee with the utility folks, should we defer the process of actually making the change, make the change by the motion, hold on to it, and then after the discussion at the next subdivision, make the full change to the bylaws, rather than have to do it twice?
Probably makes sense to just defer it, quite frankly, because if the utilities has something dramatic that they want us to do, we'd have to bring it back to you guys. Otherwise, we're amending based on what they say and then coming back again, and so, I mean, that's an easy way out, is just to defer it and wait until we get all stakeholders, back to them.
I don't dislike Mr. Warren's motion, but I'll make a substitute motion that we defer until after the subdivision had a chance to deal with the utility companies.
Second.
Okay, I have a motion by Mr. McKay, a second by Mr. Klossmeyer to defer. Any other discussion? All in favor, say aye. Aye. Opposed, same sign.
Be ready.
But keep in mind, we get
Okay.
paid by the word, so we're perfectly happy with this, so.
Motion,
Be ready to
Mr. Bill Johnson.
We are, we're going to triple.
Did we vote yet?
Yes, it was 12-0.
I'm just gonna say, we can get off on some tangents in subdivision on stuff that we're probably not even supposed to be considered. So I hate to see, if we don't have a quorum, what kind of argument we'll have in here, what we're gonna do with it.
I made that comment I said a while ago, as a developer.
Point.
Because I know anybody that's got a problem with any plat, anything, whether it's a utility company, the fire department, or whatever, they're gonna be here at the full planning commission meeting. And the developer's gonna be here to look for his side of it.
Quorums are important.
But the quorum's fine.
We didn't specify the date to which it would be deferred, but we'll bring it back on the 25th because we won't be able to turn it around and have it on your agenda for the 11th, I don't believe.
All right, agenda item number 5.2. Stephen, let's start about development trends.
I like that one.
Thank you.
It's my job.
Stephen Banks, Metropolitan Area Planning Department, Senior Planner for Advanced Plans. You have before you the 2019 Development Trends Summary. This is a report we put together each year to try to summarize subdivision, vacant lot activity, and building permit activity in all of Sedgwick County. Subdivision activity for 2019 was, or actually 2018. This summarizes the previous year's activity. So this is 2018 data. It was subdivision activity for residential was up 57% over 2017. So far this year, activity is up about 40% for 2019 compared to 2018, with residential being a large part of the increase. Regional commercial and office subdivision was also up 30% over the 5-year average, so we are, it's a solid trend up. But industrial subdivision activity fell by about 50% for the 5-year, compared to the 5-year period. Not too surprised to see this. Industrial activity tends to be a little bit more lumpy. And one thing that I think has contributed to that is we're seeing a lot of automation in the aircraft industry, which we didn't expect to see 10 or 20 years ago. We were thinking that would be a hard thing to do, but if you look at some of the YouTube videos on Spirit Aerosystems, you can see some of that robotics that they're using. Actually, a better video in terms of that kind of automation is the Jaguar automobile facility. It's a 45-minute video on YouTube. Their chassis and body are all aluminum, borrowing very heavily from the aircraft industry. And it's surprising the extent to which they're using robotics. And we're seeing that in the aircraft industry, and it's having quite an effect on number of industrial jobs as well as projections for industrial jobs into the future. Vacant buildable lot activity has been steady with 2017. The supply rate has been under that 3-year number that we like to see. I would just caution to look at the absorption rate in the geographic market you're in going forward, because there seems to be some volatility having to do with the events and so forth, the markets and so forth. We'll just have to see how those things pay out. Building permit activity, residential building permit activity fell 38% compared to 2017. Part of that was actually in multifamily. About a quarter of the fall was in just the CBD multifamily activity. We had several projects come online with completions in 2018, and kind of a little bit of a saturation of the market there. as those new projects started getting filled up. The Colorado Derby building and River Vista being a couple of those. So we'll have to see. The market is still pretty good based upon market projections for the CBD, and so I wouldn't expect that to be a long-term dampening effect. May saw nearly 15% of the net dwelling units built in the region in 2018, with Bel Air and Derby each getting about 6%. I think as Wichita's city limits have grown out toward those communities, they're actually seeing more impact with the growth pattern reaching those communities. And I don't expect that to really change. I think that will be a continuing trend. Commercial building activity for Wichita was about even with 2017. The permits were about the same in number, but the square footage was only about 74% of building activity or square footage built. And sometimes it just takes a couple really large projects to skew those numbers from year to year. For instance, when we had the airport, the numbers really shot up for that year. But it's just one factor that we look at. The small cities were at about 2017, or at a 70% of 2017 level, but their square footage was actually up. And one thing that was, I think, encouraging for me to see in that is in the past when those square footage numbers have been up in the smaller communities, it's because of school projects, USD projects. And with the exception of, I think it was Hayesville, they had a pretty large school project, but that wasn't the case this time. So they're actually seeing larger other commercial projects. Overall, the market's continued to be very active. In terms of population, we're showing about 392,000 in our estimates for Wichita and 516,300 for Sedgwick County. But Wichita's growth rate is about half of what was projected in the community investments plan. Also, we're seeing some decreases, especially within the established central area with population. And we think that is largely the result of immigration policy and the fact that many immigrants in a lot of communities have left the country or gone to other areas where they feel safer. We're not alone in this, and we'll have to see what happens with the 2020 census in terms of those counts. But it has made an effect, even though we're growing just very slightly in the overall numbers. Maize is actually almost doubling their growth rate right now in terms of what was projected in the comprehensive plan for 2035. And Bel Air is close to meeting the projected growth rate. If someone has some other questions as far as getting into the weeds with the numbers or any other questions, I'd be able to answer those at this time. I did not receive any questions via email, so.
All right, who wants to get into the weeds? Questions? Comments? Did you have something, Mr. McKay?
I got a comment, we got to find.
Okay.
Next page, or the back side of the summary sheet. On this scale, you talk about the small towns around Wichita, and you go down here that That Saul Goddard.
What page number are you on? Backside of the summary sheet.
Page 3.
Subdivision activity.
Yeah, it's the subdivision activity stuff.
Oh, okay.
Down here, Goddard had 102 and 17 and only 2. What, that seems a big disparity.
Yeah, that actually is apartment, multifamily. They also have it's associated with one of their nursing homes, but it's actually independent living project, so it's basically a multifamily project.
Questions or comments? Okay, thank you. All right, looks like we're going to set a date for the public hearing for the Delano Neighborhood Plan and agenda item number 5.3.
Good afternoon, Matthew Williams, Associate Planner. Today I'm here to ask you to set the date for the official public hearing to consider the adoption of the Delano Neighborhood Plan as an amendment to the comprehensive plan. And we're hoping to do that on July 11th. On May 4th, 2017, the Planning Commission initiated the process to amend the Delano Neighborhood Plan. The City Council appointed a Delano Advisory Committee in July of that year, and the plan took approximately 7 months to complete and involved community stakeholders from the neighborhood and around the community. It included a lot of people. The Delano Neighborhood Plan was presented to the Planning Commission on March 8th, 2018, and recommended for adoption. On April 17th, 2018, the City Council heard this case but deferred their vote over the course of several meetings until November 13th, when they voted to return the Delano Plan to the Metropolitan Area Planning Department while work was being completed on the Ballpark Village Master Plan. The Advanced Plans Committee has been kept up to date throughout this process, and the Ballpark Village Master Plan, along with some tweaks to the Delano Neighborhood Plan, has now been completed, and it's time to set the official public hearing. So I'd be happy to answer any of those questions, and the process moving forward dates are up here on the screen.
Matt, so the recent discussions that have been in the news, you feel those are covered and this should go forward as it is?
We had a Delano Plan Advisory Committee meeting earlier this week where we were hoping to get their recommendation on the plan. Based on earlier public feedback that the plan didn't include enough parking for the baseball stadium, we added in more parking to the plan. And the committee felt uncomfortable to make a vote this past week, so we're setting a new hearing for June 27th, where we hope to get their recommendation. But the plan would include also getting the DAB's recommendation on July 1st and then bringing it here July 11th.
Other questions? Okay. Need action.
Moved. Take the recommended action.
I have a motion by Mr. Richardson to set the public hearing, a second by Mr. McKay. Any other discussion? Do you have a date?
July 11th.
July 11th?
Yes.
Okay. All in favor, say aye.
Aye. Aye.
Opposed, same sign. Okay, motion carries. Anything else anybody wants to discuss? Mr. McKay? Oh, okay. We are adjourned.